Greetings. This lecture is on ethics, corporate social responsibility, and employee rights. Specifically, we're going to discuss this in the context of human resource management and the role of HR in helping to, first of all, set a good tone and culture for ethics and social responsibility in the organization. But second, also take a look at what ethical obligations HR has in terms of their own behaviors, what they should or shouldn't do or can't do based on voluntary ethical compliance issues in the field of HR. If we move to the next slide, it's entitled Employee Rights, and as you can see, there are three basic categories of rights. We've got contractual rights, which are based on a contractual agreement that we have between individuals or between corporations. We have statutory rights, which are rights that are based on laws or executive orders that are passed down, but largely they're within the realm of laws passed by Congress. And then we have other rights. And other rights is sort of within this realm of ethics. The law doesn't necessarily ascribe to it. You don't have a legal contractual agreement, but yet people still have a strong sense of what is considered to be a right or what is right or wrong in the big context. And so really, when we're thinking about ethical behaviors and ethical norms, we have to understand that they are up against what the law says is right or wrong. Laws are not always ethical, and we can go back to laws that said slavery was okay or slavery was a good thing, and realize that just because a law says we can do something doesn't mean that we should. There is a sort of a larger calling, if you will, when it comes to issues around ethics. And so fundamentally, where we're at in this lecture is trying to understand where the law ends and ethics begins. What are employer rights? What are employee rights? What is a realistic argument or fight that an employee can make? And what is considered inappropriate? Employers have enormous rights in terms of what they can expect, what they can require, we have to understand issues of compliance and issues of ethical norms in each company and how it's different. Moving to the next slide, you can see where when we think about codified law on one extreme and then sort of, abject free will on the other extreme, the ethics is kind of in the middle, which is basically doing the right thing, even if the law says you don't have to. But then, of course, our challenge is trying to decide what is the right thing. So you move to the next slide, and you can see that there's four basic ethical theories that we consider when we are doing ethical decision-making in business. Utilitarianism is a results approach. It's about greatest good for the greatest number of people. It's about maximizing happiness and minimizing pain. And so it tends to fall along the lines of democratic voting or majority rules, or doing a cost-benefit analysis for an organization. But things are not that simplistic, right? Things are much more complex than just a cost-benefit analysis, because there are other issues that we need to account for that are not really quantifiable when we do a cost-benefit analysis. Another is called the universal or moral rights approach, and that's by Kant. And Kant would argue that moral rights is basically that we have rights and duties and responsibilities to do the right thing, and that our intentions are really important. So our goal is to make sure we are doing the right thing by people based on what we believe to be our moral standard. And that moral standard may come from God, or it may come from sort of an internal compass, but nonetheless, we believe that there's a right way to do things, and that was what we should continue to do. The social justice approach is about fairness and justice, making sure that we give people an equal playing field, and if we give them an equal playing field, everybody has the same opportunity to succeed. It's not always about doing everything the same, but it's about creating as much equality as is possible, and certainly equity when it's possible. Lastly, issue of virtue ethics, and the idea that we want to be as virtuous as possible so that we have a good reputation, that we aim to be the most virtuous person that we can be. We look to role models in the community to decide how we should behave in that context. So you move to the next slide, and you can see that there's 4 basic ethical theories that we consider when we are doing ethical decision making in business. Utilitarianism is a results approach. It's about greatest good for the greatest number of people. It's about maximizing happiness and minimizing pain. And so it tends to fall along the lines of democratic voting, where majority rules, or doing a cost-benefit analysis for an organization. But things are not that simplistic, right? Things are much more complex than just a cost-benefit analysis, because there are other issues that we need to account for that are not really quantifiable when we do a cost-benefit analysis. Another is called the universal or moral rights approach, and that's by Kant. And Kant would argue that moral rights is basically that we have rights and duties and responsibilities to do the right thing, and that our intentions are really important. So our goal is to make sure we are doing the right thing by people based on what we believe to be our moral standard. And that moral standard may come from God, or it may come from sort of an internal compass, but nonetheless, we believe that there's a right way to do things, and that was what we should continue to do. The social justice approach is about fairness and justice, making sure that we give people an equal playing field, and if we give them an equal playing field, everybody has the same opportunity to succeed. It's not always about doing everything the same, but it's about creating as much equality as is possible, and certainly equity when it's possible. Lastly, issue of virtue ethics, and the idea that we want to be as virtuous as possible so that we have a good reputation, that we aim to be the most virtuous person that we can be. We look to role models in the community to decide how we should behave in that context. Next slide is the role of HR in ethics. And HR plays an enormous role. First of all, the Society for Human Resource Management has its own code of ethics that HR professionals need to follow, that you need to make sure that you are not allowing bias into the performance appraisal process, that you're not supposed to take gifts from vendors, that you don't misrepresent hours on timesheets for yourself or for others, that you don't discriminate. And many of these things, again, are coded into law, but they're also an ethical code. So just because something's an ethical code doesn't mean it can't be a law. It just doesn't necessarily have to be a law. HR also plays a role in terms of Sarbanes-Oxley. If you move on to the next slide. Sarbanes-Oxley, as many of you know, was passed by Congress to make sure that publicly held corporations are following certain accounting controls and managing appropriate and inappropriate behaviors. It requires the company to have an ethical code that it communicates to people, that it has a complaint system in place for people to be able to report a problem if they have it. It makes sure that there's anti-retaliation for whistleblowers, and it helps to verify attendance and payroll policies. And so HR plays a very key role in all of those aspects, making sure that we have important policies and procedures set up to address these issues, particularly the executive compensation and benefits issues. In the next slide, actually the next 4 slides, gets at some miniature cases in ethics training. Our objective in ethics training is not to teach people ethics, but to teach them about what is considered an ethical dilemma within the boundaries of their job, and how the organization wants them to respond. This is a compliance program, basically, is what we're thinking about here. In compliance programs, we're requiring people to behave in a certain way, and even if they may be allowed to do other behaviors, we make the agreement amongst ourselves and the company that these are the only behaviors that are appropriate to us within the boundaries of ethics. A lot of times, though, people don't follow those, and you'll find that when someone is ready to engage in an unethical behavior, or they start engaging in rationalizations, that's a really great signal that they're facing an ethical dilemma. When you say it's not legal or immoral, it's not illegal or immoral, or you say it's not in my best interest to do this, or you figure no one's going to find out, my company's going to condone this activity. When you rationalize those behaviors, that's a clue to yourself that you're facing a dilemma. So these training programs will start to work with you on making sure you understand illegal or immoral behavior, what is considered inappropriate, what are considered typical rationalizations for the company, and where are the boundary conditions between appropriate and inappropriate for that particular company. The next 3 slides I'm not going to review, but they're great examples of the types of ethical dilemmas that HR professionals will experience. One is working as an HR representative, dealing with a layoff. The other one is working as a training coordinator, and the other one is a college recruiter. And in all circumstances, the HR professional in these cases has to make a decision regarding this balance between company policy and what is considered to be ethical or unethical. So we will find an opportunity to debrief and discuss these. Moving on to the next slide, we have the issue of corporate social responsibility. And many organizations and many people would argue that organizations are responsible for the welfare not only of the corporation but of society at large, and to do the right thing by their colleagues in terms of not harming people in that context. The problem is we all have different definitions of what is a benefit and what is a harm. What might be a benefit to one person could be a harm to another, so that becomes a challenge. It's also really challenging to figure out which stakeholders are important and how we would value them in that situation. And we also have to recognize that a lot of times the things that we consider are appropriate might be very ambiguous in terms of implementation. So obviously there's all sorts of characteristics and issues that you need to think about as you're determining what's the right direction in terms of corporate social responsibility. But nonetheless, these are issues to address nonetheless. So the next slide says, how do we evaluate corporate social performance? And it's a 4-pronged approach, and each leads and builds on the other. We start out at the basics, which is economic responsibility, where we have a responsibility to be profitable. But does that mean that we should be profitable and do things illegally or inappropriately or unethically? Not necessarily. But a lot of times you can make money and be illegal or unethical, and you make tons of money. I mean, drug dealers do this, people who cheat others, blackmail, things like that. They're all engaged in illegal activities, and nonetheless, they're very profitable. Doesn't mean it's legal profit or ethical profit, but it's profit nonetheless. So we do have a first responsibility to be profitable, but the challenge that we have is if we just tell people to worry about making money and we don't give them boundary conditions on how to behave, you're going to end up with illegal and unethical behaviors. So the next level of responsibility we have is to make sure we're within the boundaries of the law. At a minimum, we need to be within the boundaries of the law. As we know, the law isn't always right. Many times the law lags behind ethical outrage, and we've had some discussions about how we might say this is inappropriate behavior, and then ultimately the law catches up and they say, oh, okay, fine, we'll write a law that says you can't do that anymore. So we recognize that the law isn't always on the leading edge of what's right or wrong, but ultimately it tries to address what's right or wrong. Many times, though, even when it thinks it's in the right, for example, the idea of owning people and owning slaves, we recognize that even though the law said we could do that, we recognize that as an inappropriate thing to do, and ultimately that law was changed. Our next level of responsibility is the ethical responsibility, and again, it's not enough to make profit, it's not enough to be legally responsible to law and to your company, but also to do things ethically. to do the right thing and to avoid harm to others. Lastly, we have what we call a discretionary responsibility. This is where no one's breathing down our back to do this, but we are obligated to try to contribute to the community and to the quality of life of all the people around us, taking into account all of our stakeholders, taking into account what people in the community might need. So if we do a layoff, recognize that when we do layoffs, it hurts other people, and it hurts the community because the community now doesn't have the same income base that it had before. Our next slide is dealing with some of other employee rights issues, for example, contracts, non-compete agreements, intellectual property issues, employment practice liability issues. So the next three slides get at some bigger picture policy issues that we need to consider as HR professionals. In terms of contracts, we talked about different types of employee rights, and one of them was contractual rights beyond the statutory. And the contractual rights talk about who is in the agreement, what the agreement is, what the terms are, whether or not it's a renewable term, whether or not there's any non-compete issues or termination factors that might be into play. But when we're creating an employment contract, these are the factors that we want to consider in that. Who's the party to the contract? What are the duties and expectations? What's the compensation for it? What are the terms? How can somebody be terminated, or under what conditions can they resign, and what do they get if that happens? We tend to call those golden parachutes, when people resign and they come to an agreement in advance about what they will get when they leave. There's also non-compete or non-piracy agreements, which we'll talk about in a few moments, and also how do we handle intellectual property, what is owned by the company versus what is owned by the individual. Our next slide talks about the non-compete agreement, and in the non-compete agreement, it's how we set up a separate agreement about the relationship between the employer and the employee. What it does is it prohibits the employee who's leaving the organization to work in the same area and in the same field over a certain period of time. It can't be indefinite. And it can't be onerous to the person, but you can say for 6 months you can't work in this industry. So let's say you were the head of marketing for Anheuser-Busch and you decided to leave and go into your own business. You couldn't go into business for yourself as a marketing rep. You would have to take 6 months off or work somewhere else or do something else for 6 months, and then you could go into business for yourself 6 months later. That would be part of the agreement that you would have. The goal is the company doesn't want you to take the things that you learn from them and use it against them in a competitive environment, but also to use it to enhance yourself in that situation. A non-piracy agreement basically bars employees from soliciting business from former customers or clients. So if you leave and you go to another company, you can't go to the clients of the company that you used to work for and tell them to come and follow you. Now, if they choose to leave of their own volition, it's a separate issue, but you can't pirate them, steal them away, and take them without some sort of acknowledgement and agreement. A non-solicitation of current employees means that you cannot start your own business and then go back and ask those people to leave, to come and join your firm, and to leave the other location. So there's all sorts of different types of non-compete agreements that we would have to consider, and that may or may not be relevant to the company. In the next slide, we deal with a thing called intellectual property. And in 1996, the federal law said that the theft of trade secrets is a crime. So employers have the right to keep their secrets. You know, Coca-Cola keeps their secret about what their recipe is for Coca-Cola. Same thing with Kentucky Fried Chicken. You know, anything that's a specialty item that is unique and has a competitive advantage and is protected is something that the employer can keep and protect. And there's only one person, I think, that has the entire recipe for Coca-Cola. There are people that have different parts of it, but there's only one person that has all of it in one location. So trade secrets are supposed to be kept confidential, and you have to honor that. If you are developing a product or a service, your goal is to bring the opportunity to your employer first, to give them the right of first refusal. If they say, we don't care, you're welcome to do your own thing, you can then take your project and your service and go out on your own and make money doing that. But when you're designing something on the company time, or you're under the employ of a particular business, they many times will own your intellectual property. Anything that you do that's related to their business, they're hiring you to help them to be better. So the last thing they want to do is to have you go off and do your own thing and develop ideas that they can't utilize. So this idea of trade secrets is really important, and they're entitled to that right of first refusal. Copyrights are also a big part of that. So for works or documents that you've created, you can create your own copyright on those materials. The next thing I want to talk about is employment practices liability insurance, and this is the kind of insurance that some companies can get, which will cover legal fees and settlements and judgments about any kind of employment actions. So basically you have insurance like this to protect you if you get sued by an employee or a potential employee for certain things, and it covers your legal fees and things like that, so you don't go bankrupt over that. In order to do that, though, the insurance company has to review your policy manuals, your handbooks, all your employment forms, and past employment-related charges over the last few years to make sure you're not a high risk. If you're a high risk, then they're either not going to insure you, or they're going to increase the costs for that policy to be able to do that. Next couple of slides are dealing with some issues on where individual rights and employer rights sort of combat each other. There are, in some locations and in some places, individuals have rights to privacy and to kind of do their own thing, but in other situations, the employer gets to make the rules about what is or is not appropriate. So let's start with the blogs, wikis, and Facebook and MySpace. And as you know, free speech is not unrestricted in the workplace. You don't get to say whatever you want, and you certainly don't get to say whatever you want about the employer in a public forum, because you'll get fired for it. So you can't speak negatively about your employer on Facebook, or if MySpace were existing, or in any kind of blogs or wikis that are out there. Anything that identifies you and the company together, not a good plan. You can be fired or disciplined for saying all sorts of different things on your blogs or networks. The things that you can't say: no negative comments about the employer. You can't have very extreme political views, although in some situations like California or New York, you're exempt from that. You can't have this sexually explicit material. It's not protected. And if there's very controversial views, you're protected in California and New York to be able to have your own opinion on something. But other than that, you will get in trouble otherwise by an employer. There are a lot of employers out there that are actually requesting Facebook or LinkedIn passwords in order to be able to see candidates in advance and get a good sense of them. And we've already discussed this when we talked about some of the challenges of technology and social media. And as you know, the state of Illinois it's illegal to ask for someone's Facebook password, but it's also, not a bad idea to have a Facebook profile that is anonymous for your own personal use, and then one that you might have for professional reasons and professional relationships. To have a good face to put forward. In terms of whistleblowers, we know that they're protected under Sarbanes-Oxley. And the process for whistleblowing should go like this. You should try to go to your federal regulatory agency or law enforcement agency first if you find that there's a problem, an ethical dilemma, or an illegal issue going on at work where you need to whistleblow. So that's the first step. The second step is, if no one responds to that, you have the right to go to Congress or to your supervisor. Any one of those are appropriate groups that you can respond to. And when you have exhausted all three of those and nothing seems to work, then and only then does it make sense to go to the media. But before you go to the media, make sure you've exhausted all your possibilities in terms of regulatory agencies, Congress, or your direct supervisor or your ethical officer in your company. And so whistleblowing will be protected. In terms of other rights, in terms of dress codes, things like jewelry and body art and piercings, you don't have a lot of leeway in that. The company makes the rules. They make the rules about what kind of jewelry is appropriate, what kind of body art is appropriate, what kind of clothing you can wear, piercings, and things of that nature. And I believe we've had a discussion about those issues in fairly big detail in the beginning of the semester. So these rules are things that we need to to keep in mind that you don't get to express yourself so freely in the workplace. You are responsible for making sure you stick within the guidelines of what the company says is appropriate behaviors and appropriate things to wear. In terms of drug testing, we want to make sure that we have a drug testing policy that is fair, that manages due process. As it says here, 84% of employers use drug testing as a pre-screening tool to make sure that you're not engaged in any kind of illegal behaviors. It is absolutely required for some categories like pilots and military personnel. Part of your policy for setting up a drug testing policy is how do you handle certain situations? If you have a positive result, for example, what do? Do you assume that they're guilty, or do you give them a second chance? A lot of times companies will give them a retest because there are times when you can have a false positive. That happens. If there's a false positive, how do you handle that in terms of the person's personal records? Do you then test them again in a little bit to make sure that it was a false positive, or to see if whether or not it was a true positive? You also want to make sure that the specimen is held securely so that there's no room for faking. It used to be that people would bring in somebody else's urine and bring that to the drug test, and it got to the point where employers and labs can test for the temperature of the urine. If the urine is not at a certain temperature, then they recognize that it was not yours, because it would be at a certain temperature because it was in your body. If you've been carrying it, the temperature will decrease, absolutely, and so they can test for that, and it has to be within a certain range over a certain period of time. And if it's lower than that, then obviously it means that you've brought in a false sample. So there has to be a good chain of command of who has the sample to make sure that there's no room for any kind of bias or contamination that goes in the process. So in terms of testing people, remember we talked about the whole issue of random drug tests, and how the random drug tests can stop people from engaging in drug-taking behaviors, because the random reinforcement of the law, no one knows when they're going to be called, no one knows how many times they're going to be asked to drop their pants and do a drug test. So we should make it random for everybody. Sometimes, though, we might only want to do a test if there's a probable cause, if someone is doing drugs, and so we might make the policy that no one gets tested unless we think that you're doing drugs, in which case then we'll test you. And we may also say, regardless of whether or not we have a pre-screening or a random testing policy, if there's an accident in the job, we want to make sure everybody gets drug tested who was involved in the process. The last couple slides are dealing with office romance, office off-duty behaviors, and electronic monitoring. It is okay to monitor your employees, but it is not okay to do it when they're not aware. So we do this because we want to make sure we minimize theft and espionage, but we also want to make sure we're not engaging in inappropriate behaviors. For example, putting cameras in bathrooms or changing rooms where people may be in various stages of undress. We want to make sure that we use appropriate things and that people are aware of it. And it also may help us if we try to find a positive use for those monitoring. For example, if it helps us with more productivity, we can use the monitoring as a tool to monitor for inappropriate behaviors, but also to improve productivities. So make sure you have it in writing, make sure it's communicated well, and make sure that people are aware of the policies. And the same thing for any kind of internet use policies. We don't want to surprise people. We want a reasonable policy for how to use internet and what we can have access to on the internet. In terms of office romance, obviously companies vary from anything from a no dating policy very strictly to an extreme case of allowing workplace romances no problem and requiring what we call a love contract, which is sort of an interesting approach to things. So the love contract basically says that you go in to the employer, to the HR department, to your boss, and you say to them, we are in a relationship, these are the boundary conditions of that relationship, and we're in this voluntarily, it's not coercive in any way, and you keep that on record so that there's no chance later on, if the relationship ends, that the person can come back and say, well, they used me, I was coerced. you're already making an agreement up front that you are you're in it voluntarily. What it tries to do is it minimizes the risk for sexual harassment, and making sure that we don't have people who, for example, are married that may engage in embezzling money together, because you can't be compelled to testify against your spouse. You can voluntarily do it, but you can't be compelled to do it, and in which case then married couples could work in partnership to steal money from the company, and then you wouldn't be able to do that. So a lot of companies, and particularly banks and other financial institutions, may say married couples are not allowed to work together, or at least not working together in related departments where something like that could occur. The last thing is about off-duty behavior, and recognizing that even though society does have some reservations about intruding into our personal lives, it's also very important that we behave in a way that does not put the company in financial jeopardy. We are representing the company many times when we're out there, particularly if we're at a bar, if we're at a conference, if we're doing work-related business. But there are a lot of businesses out there that are trying to regulate not only the things you do when you're on the company clock, but also off the company clock, by no smoking, no drinking, using competitor products, gaining weight, or having excessive political bumper stickers. For example, if you're interviewing for a job with Anheuser-Busch, the last thing you want to be doing is ordering a Blue Moon when you're out to dinner, because Blue Moon is not an Anheuser-Busch product. And there are case studies of individuals who have done that and have never gotten the job. So if you work for a company where their product is very visible, you're expected to use that product in a visible way so that other people know that you're using it. So I know plenty of people that work for AB who are required to order it when they're out. If they're going to order a beer, they had to serve it in their homes. They can't have other products in their homes. It's very restrictive. So you have to keep those sorts of things in mind. So just to give you a good flavor of how the employee and the employer have sometimes competing rights, it all falls within the realm of ethics and what is appropriate behavior and how the company should decide what appropriate behavior is. We have to have compliance programs with training and very clear rules about what is or is not appropriate. We want to make sure we put these policies in writing, through non-compete clauses and things like that. So everything is very clear for our employees what they can and cannot do. All right, so if you have any questions, let me know. Otherwise, this is the end of the lecture, and I'll talk to you later. Bye.